Section 56 lays down a rule of positive law and does not leave the matter to be determined according to the intention of the parties. This is to be kept in mind. It's a rule of positive law. It does not depend upon the intention of the parties. By contrast, Section 56, 55 we saw that the intention of the parties was very relevant, very material, but not so in Section 56. Now, according to Section 9, a promise may be either expressed or implied. And in cases where the court gathers as a matter of construction that the contract itself contained impliedly or expressly a term according to which it would stand discharged on the happening of certain circumstances. If the contract itself provided that if such and such eventuality happens, then the contract will stand discharged, the contract will come to an end. Then on the happening of those circumstances, the dissolution of the contract would take place under the terms of the contract itself, and such cases would be outside the purview of Section 56 altogether. If the parties had earlier agreed that on the happening of such and such thing, the contract will come to an end, then obviously there is no need to apply Section 56 because under the terms of the contract itself, the contract would come to an end. When the change of circumstances is so fundamental as to be regarded by law as striking at the root of the contract as a whole. Now we are talking of change of circumstances, but not every change of circumstance. Only that change of circumstance which is so fundamental that it strikes at the root of the contract, then the court can pronounce the contract to be frustrated and at an end. It is not the parties which are bringing the contract to an end. It is the court which is pronouncing the end of the contract. And why? Because there is a change of circumstance and the change is so fundamental that it is striking at the root.